is not the time to mention.
On the last occasion, you suggested at mentioning in the.
Not at what time.
From the supplementary list, under heading for orders, item 1, DA 1898 of 2026.
The provision date is confirmed.
Under heading for admission, item 2, DA 104 of 2026.
It's correct, one. There is a petition passed. Last time नहीं आई थी. Last time नहीं आई थी.
कल नहीं है.
जी तो नहीं आइएगा.
नहीं हाँ ठीक है.
तो हम डिस्कस करते हैं. एक ही बार एडजमेंट देंगे. दूसरा कोई एडजमेंट.
Item 3, DA 1329 of 2026.
Rising tax for the
He is about to join. You said that the court is vacant. He is about to join.
some new facts which I am submitting before my lordship. That the fact is that the occurrence took place on 18th of October 2025 and 225 first occurrence, and thereafter she died on 19th of October 2025. But from the FIR, from the provision of FIR, the case was registered on 4th of October, 4th of November 2025. Such inordinate delay cast doubt, conjecture and surmises about the fairness and truth and veracity of the present prosecution case. In the instant case, the prisoner is judicial incarnation from 4th of November 2025 till date. If a single day of incarnation cast doubt and conjecture and surprises into an individual's life and liberty of an individual is very much precious. Here in this instant case, the informer's wife and the mother of the victim has been examined by the learned lower court, and in her examination she has been declared hostile. She has not supported the prosecution case. Here in this instant case, the entire case is false, fabricated and concocted from the provision of page number 30 FIR. I am going to this occurrence that is on 18th of October 2025.
What is the allegation?
File number 3, page number 13 FIR, first information report. File number 13. Occurrence of offense date from 18th.
I want to know what is the allegation.
Allegation is that she died at
Who died? How are you related?
Yes.
I am
He not able to.
they are creating inroads into the life. I am going to the FIR part. First I am going to the FIR. They allow me to read the FIR. हमारा नाम ललित प्रजापति, उम्र करीब 42 इयर्स, बालिका उम्र करीब खंडवा काटी जरिया हरियाणा के निवासी। आज दिनांक 19/10/25 11:10 बजे एएमसी निकाली मेडिकल कॉलेज अस्पताल हरियाणा पोस्टमार्टम।
ये तो गए तो 19 ही तारीख को गए हैं। रजिस्टर भले बाद में होगा।
रजिस्टर बाद हो गया 19 तारीख को गया है। डेट
19 तारीख को ही है। ये नोटिंग नहीं 19 तारीख।
19 तारीख को, but the case was registered on 4th.
Maybe whatever be, but every noting is of
The first occurrence took place on 18th. The allegation is that on 18th of October 2025 she was abducted, but the matter has been reported when she died. What the informed party had been doing at home? Why they did not inform the local police the police station is just 6 kilometers away from the place of our offense. My lordship will need to kindly find that the case has been registered not on 19th of October 2025, but it has been registered on 4th of November 2025. This inordinate delay creates doubt, conjecture, and surmises about the fairness of the present case. Moreover, I would like to submit before my lordship that the informant's wife, that the mother of the victim, has been examined by the London lower court. She has not supported the entire prosecution case, and she has been declared hostile. The cause of death is due to poisoning. She consumed poison at her parental home, not elsewhere. When the informant party, the mother of the victim was working at Polytechnic along with other laborers. The petitioner is also the laborer, and her entire family members were the laborers who were sowing potato.
The learned counsel for the petitioner
There is no criminal accident.
as per the FIR, the alleged incident is of 18/10/2025. The victim died on 19/10/2025.
Entire process is
And though the information to the police is dated 19/10/25, but the FIR has been instituted only on 4/11/2025. The learned counsel submits that there is inordinate delay in registering the FIR. He has also submitted that the victim had consumed poison at her home, and the mother of the victim, who has been examined as Peter 1, has been declared hostile. He submits that the petitioner is in custody since 4/11/25. आपको क्या बोलना है?
Lordship, on the last occasion, this matter was in the deposition, the mother has directly in her chief. She has stated that Sabine मिलकर मेरी बेटी को मारपीट कर घायल कर दिया.
after being declared as an
That has been come and in the postmortem report also.
hostile, after being declared hostile, this deposition has been incorporated in the deposition by the London lower court.
This
आपको
This
इनका
is not
प्रोसेस स्टोरी को समझ नहीं आया, आप बताइए क्या कहा?
interesting story is that the deceased person appears with this petitioner. The petitioner forced the girl to marry. The girl refused. The was asserted according to see or consuming the poison herself. This is the case.
Where did she die?
She died at her. She come from that the boy house of the boy in school.
From house of the boy, she was taken to the hospital.
From her own house, she returned from there and married and she mother says that
And she consumed poison at
she
home.
was sick. Consumed poison.
She was assaulted.
She was assaulted. This has come by this is stated by mother in the postmortem report that has come. Postmortem report there is a clear that is clear.
Is there any injury in this one?
Yes, not in the postmortem report there is clear. The noted aversion there are scratch of aversion. The noted aversion are anti-mortem in nature caused by heart and blood surplus.
You are for whom?
Prescribed for the state. And on
You
the
are for
last,
whom?
Alcohol important. So all the 5% were done in FIR, but they have kidnapped. But they are responsible.
The learned counsel for the state.
But I would like to submit that
Sir, please, इतना नहीं बेल में इतना नहीं बहस हो सकता, ठीक है? There is direct allegation
I would like to submit that so that this honorable court will come on righteous conclusion.
Sir,
They
time नहीं
have
चल रहा है.
submitted wrong submission before the honorable after being declared as hostile.
So अभी ट्रायल से एक्यूटल कर दें, क्वेश्चन फाइल कर दीजिए यहाँ से. एक नित्य हॉस्टाइल हो गया है, so entire proceeding should be quashed. Do something about it. कुछ नया लॉ ले डाउन कराइए. कि मदर अगर हॉस्टाइल हो जाए विटनेस की, तो सारा प्रोसिक्यूशन केस खत्म हो जाए.
But there is no evidence here, they have not submitted the right thing.
बस अब आप प्लीज होल्ड ऑन. Please hold on.
And the internet
I heard you
submitted right thing before this.
I heard you enough. The learning counsel for the opposite party. has opposed the prayer and has submitted that as per the allegation, the petitioner and the victim had affair, and on account of both being in different castes, she had there was a refusal for marriage. However, when she went to the house of the petitioner, she was assaulted, and after returning from there, she committed suicide.
Time has also
He has also submitted
when she
that.
was assaulted, when she was
Yes,
abducted.
he has also submitted that as per the postmortem report, there are anti-mortem injuries. After hearing the learned counsel for the parties and considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail merely because the mother of the petitioner is said to have turned hostile. The same is not a reason to grant bail to the petitioner at this stage. However, the state is directed to ensure that the remaining witnesses are to the court,
And
the counsel for the state is directed to communicate this order to the director of prosecution and superintendent of police of the concerned district.
Item 4, DA 1382 of 2026.
Yes.
Has been registered for the offence under section 376 KG and 4 and 18 of Oxford.
Victim is less than 12 years. Correct. 3 out of 9 witnesses were examined as on 10/6/24, and 7 witnesses were examined till 10/9/24. बाकी witnesses सब तो 2 witness बचा. Sorry? किस लिए? Why do you need time? For the learned counsel appearing on behalf of the party, the learned counsel for the petition submits that the petitioner has been falsely implicated in this case and he is in custody since
24/4/2026.
24/4/2023. However, the records of the case reveal that the victim was less than 12 years of age and 7 witnesses were examined till 10/9/2025 out of total 9 witnesses. It appears that the trial is at the tag end. This court finds that there are direct allegations against the petitioner and the alleged offence is of heinous nature. Accordingly, this court is not inclined to enlarge the petitioner on bail. The state is directed to ensure that the remaining 2 witnesses are also promptly produced before the court so that the trial is taken to a logical end. The counsel for the state is directed to communicate this order to the superintendent of police of the concerned district and also to the director of prosecution. State नहीं है इसमें. State नहीं है. Who is for the state in this case?
I was going through the case diary.
You are there in this case?
Yes.
Are you there?
Yes.
Yes. आप communicate करिए. बाकी दोनों witness produce करिए. इतना दिन तक ऐसे नहीं रख सकते. Produce.
There are witnesses in this case where they have seen that
आप कहाँ हैं? 7 witnesses have been examined out of 9. You get 2 witnesses examined. बस इतना ही. Next date कब है आपके पास?
As per online record, it is listed for judgment on 24/6/24/2025. As per online record.
कोई बात नहीं. उसमें लिखिएगा remaining witnesses if not already examined. ठीक है?
Item 5, DA 1413 of 2026.
But in this party, General Lordship, he has come to know by the family member that the wife of the informant has gone along with this petitioner also. And both petitioner and victim are the major blend also. And victim have given 180 BS statement. And she is really stated. If they went in Hyderabad and they had returned by plane, so we both have the consenting party also.
Offices, the state is directed to file a counter. You get it?
ये मंगाया गया था
183 statement.
180.
Thank you. She has supported that case.
She is supported that it's a allegation is true also.
Yes.
Kindly consider कि both are the consenting party and in one
Consenting party कहाँ से बोल रहे हैं?
इसलिए बोल रहे हूँ कि आप देखें इसमें कि हैदराबाद तक साथ मिलकर ट्रेड के साथ but she did not raise Iraq and it has also stated कि by plane she arrived and both are the major lordship and this petition in custody since 17/9/2025 और जब तक इसको जब FIR में ऐसा कुछ भी नहीं है और जब तक वो आई जो इन फॉर्म केस she has implicated this petition in the instant case 180 का स्टेटमेंट भी जो है लिख दिया है उसमें कहती है कि मैं तुमको इतनी रजामंद साहब मुझे हैदराबाद ले गया वहां से रूम रेंट रखा मुझे जबरदस्ती से बनाए मेरे मना करने पर जान धमकी दे रहा था
However, counsel is appearing on behalf of the parties. The statement of the victim recorded under section 183 BNSS has been produced in seal cover. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and the victim and the petitioner are major, and while the victim was allegedly being taken to Hyderabad, she did not raise any alarm, and ultimately she came back home. The learned counsel for the state has opposed the prayer and has submitted that there is direct allegation against the petitioner, and the victim has supported the allegation under section 183 of BNSS by stating that while she had gone out to attend natural call, the petitioner had used toxic material handkerchief and closed her mouth, and then she found herself in the train. And the petitioner had taken her to Hyderabad and forcibly committed rape by threatening her. After considering the arguments of the parties and the statement of the victim recorded under section 183 BNSS and the direct nature of allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail case rejected.
Item 6, DA.15.04.2026. of 2026.
Praying for Lord.
There are the cases of co-accused. Is it based on some other day? Yes. There are a number of co-accused in this case. Is it a big one? 185526. 185526.
Two co-accused guys lगा हुआ है.
हाँ. Serial number 185526. आगे है. दूसरा सीरियल नंबर बताइए. और एक है ये आइटम 12 है.
जी.
आज के
जी. सप्लीमेंट्री का आइटम 12 एंड 13
विथ 13. और ये वाला सीरियल नंबर कितना है? ये सीरियल नंबर कितना है?
ये जो अभी हम बात कर रहे थे वो है आइटम 6.
आइटम 6. 12 13 का फाइल. We pass an appropriate order when we reach 12. At that point of time, we tag all this and then pass.
I have received the case diary and it has come, there were two victims from
Where
the
is the
mobile.
case? You have received the case diary? You have received the case diary?
Yes, sir.
What about antecedent report?
Antecedents report is not in the case diary, but if the victims are there.
Victims are there, but antecedent is important.
Antecedent.
You just wait for some time. When we reach 12 and 13, we'll pass an application. In presence of the council, that those councils are also required to be heard.
Item 7, DA 1498 of 2026.
This is the section 64M and DT.15.04 of PLS 23. So far as the petitioner is concerned, it is the sole accused named in the FIR. The FIR is based on a type written report which is at page 21. Type written report made by the victim.
There is a direct allegation against him.
It is there, but only something which may be relevant for the purpose of consideration of the prayer for spirit. The victim is about 19 years. He says that through Instagram ID.
Victim is 19 years.
19 years.
Yes.
19 years. And her date of birth is not 2003, which has come during investigation also. And she says that through Instagram ID, she came to be introduced with this petitioner, and then the allegation comes that this petitioner, by alluring her, asking her to make video calls, and then in that manner, this petitioner by somehow exciting her, got her objectionable videos and photos. That is one part of the allegation. So there, so far as use of force or something that perhaps is lacking. She says that it is by way of allurement and by setting the rest. And then And she says that she fell in trap, and then she further alleges the second part that on the
Did you inform her that you were making a video
she says,
at the time of making video?
she does not say so far as the allegation I was reading it. She does not say that she was not unaware about that. She does not say that time is.
There are other cases also against
Two other cases that is on record. One filed by the mother and daughter. Two other cases, mother and daughter.
of the same family.
No,
Different
of the same place, mother and daughter. And there in both the same cases.
Mother and daughter means in one case another victim is there, but mother is the informant.
Yes.
And in another case the victim is the informant.
Yes,
So
yes.
similar nature you have three cases.
Those two cases, if I am allowed to just.
You have been imputed.
Those are the petitioner is on bail. The trial is underway in those two cases. And so far as this case is concerned, one date, except for one date, that is of 26/5/2025. Page 21, the last part of the written report will show that only one date is mentioned, 26/5/2025, when she says that on that day she was called by intimidation by this petitioner to some hotel in Nayamur, Bokaro. And that Bokaro Nayamur is quite far away. We have stated that about 50 kilometers away from her house. And then 26/5/2025, she says that calling her to that hotel, and there this petitioner has committed wrong with her several times. That is one part. 26/5/25. That is the only date apart from the. And now this case has been lost after 3 months. 26/5 is that date of coming to the hotel, and all other allegations are, as it appears from the reading, that prior date. And this case has been lodged in the month of September, August 27th, August 25 on this written report. So these are some mitigating circumstances which may just dilute the offences are concerned for the purpose of consideration of the prayer for peace. And now after investigation, the charge sheet has been submitted. There is no charge sheet till now for the offences under the Information Technology Act. So far as making of objectionable videos and spreading those videos, those allegations. So those are not substantiated till now during investigation, because the charge sheet has been submitted, keeping investigation pending with respect to those offences of Information Technology Act, saying that the official reports and all these things are awaited with regard to those.
We call for the FSL. Produce the FSL. FSL report तो वीडियो का भी होगा और उसका मेडिकल एग्जामिनेशन भी होगा.
A medical examination report has there the police reports.
The learned counsel for the state is directed to file a counter affidavit in this case and also produce a copy of the FSL report in seal covered with police. FSL report will be there for the mobile as well as the examination of the. कब रखने देते हैं?
3.
Post on 6th of May.
Item 8, BA1633 of 2026.
Procedural for written evidence.
Counsel for the petition seeks permission to withdraw this petition. Accordingly, this petition is dismissed as well.
Fine. Item 9, BA1761 of 2026.
Also. दिखाई जरा खाई. तो एक्यूज के क्या स्टेटस है? Pass over.
Item 10, BA1801 of 2026.
Section 137 to 87, 64 BLS and fuel and 6 of case like this, you know, that on the earlier date, you know, on 8/10/25, he was not in the class. And on the midnight of the same day, her minor or two daughter was missing. And on such she could not find her. And on 13/10/25, when her daughter returned back and on asking, told her that the petitioner had made filter registration forcibly and hence. You also, under section 183 of BNSS, your Lordship, she had accepted that earlier she was in relationship with the petitioner. But subsequently that relationship broke, your Lordship. And as far as medical age is concerned, your Lordship, she has refused for medical examination.
She's 15 years of age.
She has stated, but she measured, your Lordship.
From where do you say?
Your
She's
Lordship
measured?
has, though the diary is not with me, your Lordship, but under verse 183 of BNSS.
Her declaration is of no consequence. Her declaration is of no consequence. What is the age of the victim? Medical examination, there is nothing.
Medical examination has not been done since she has refused for medical examination. One 83 वाला part लिया जाता है उसके बाद, क्योंकि that statement is not with us.
The incident had happened in the house of the informant of the victim.
She was missing from her house, your Honor. But FIR has been known after the delay of 6 days. And no explanation of delay has been given.
Certificate issued by the student, she is 15 years of age, and although she has refused for medical examination, but in the 160 plus statement, she 180 statement, she has supported the prosecution case, and because age is immaterial, she is 15 years of age. Consent parties.
Or the learned counsel appealing on behalf of the parties, the learned counsel for the petitioner submits that although it is alleged that the victim was 15 years of age, but actually she is major. He has further stated that the victim was found missing from her home, and when she returned after a couple of days, she alleged that the petitioner had established physical relationship with her forcefully and had taken away and had taken her away. The learned counsel for the petitioner has submitted that, as per the statement recorded under section 183 BNSS, and as mentioned in the review order, the victim was in relationship with the petitioner and there was a breakup, and in the night on 8/10/25, he persuaded victim to open the gate, and ultimately she was taken away and expelled. The learned counsel submits that since there was a love affair between the victim and the petitioner had been falsely implicated in this case. The learned counsel for the state has submitted that during the investigation, it has come from the school records that the victim was only 15 years of age, and therefore consent or love affair has no relevance. So, after hearing the learned counsel for the parties and considering the age of the victim, which has been found during the investigation, and the serious nature of allegation, this court is not inclined to enlarge the petitioner on the case.
My parents will be.
उनका appearance, अपने appearance से लीजिए.
Item 11, BA 1821 of 2026.
Take the counsel for the petition system and withdraw his bail application and coordinate this petition with the sisters.
Cycle. Item 12, BA 1855 of 2026. Item what item?
12 and 6 and 13 भी होगा ना सर?
13 and 6.
Where is the petitioner? No, petitioner is absent. Case diary का है? Case diary आ गया, counter आ गया. जब case diary आ गया, counter आ गया, तो serial number 6 भी हो सकता है साथ में. It is arising out of the same event. Right? Serial number 6 में कौन? State.
State प्रिया श्रेष्ठ.
प्रिया श्रेष्ठ. तो antecedent जो है इसका खाली मंगा लेते हैं तो हो जाए. कलर करके. Antecedent तो आप लोग को मिल जाता है ना तुरंत. Antecedent पहनने में कोई दिक्कत नहीं है, कल तक आ जाएगा ना. ठीक.
तो मंडे को आ गया.
कल नहीं, परसों, ट्यूसडे, फ्राइडे. फ्राइडे का बोर्ड नहीं बना है. Serial number 12, 13 and 6, 12 and 13. All these cases arise out of same FIR. In BA number 1855 of 26, a counter affidavit has been filed. The case ID has been received in BA number 1855 of 26. इसी में आया ना case ID. Post these cases on Friday, the counsel for the state is directed to produce the criminal antecedent report. तीनों एक साथ क्या करती हैं? 12, 13 and 6 आपका एंटीसीडेंट, सबका एंटीसीडेंट रिपोर्ट भी आ जाएगा, तब एक साथ सुनेंगे परसों फ्राइडे.
Item 14, BA 2107 of 2026.
Section 6 of Oxford. The petitioner is the uncle of the victim and your worship, he is born as 90 years old, and it is highly improbable that the alleged offence was committed in the
70-year person cannot commit rape.
Lodged after 1.5 months.
The order is of 15/4/25, 1 year back, and only 2 witnesses were remained to be examined. Why?
Custody since 19/1/2026.
Trial is at advanced stage with expedited examination of the state. All the learned counsels are pleading on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case and he is of advanced age of 72 years. And the victim is a minor, aged
16.
Is and was below 16 years as her date of birth was 14/6/2010. The Learned Council has further submitted that there is delay in filing the FIR, enormous delay in filing it. The Learned Council further state has opposed the prayer and has submitted that there is direct allegation against the petitioner and the improved order is dated 15/4/2025, which indicates that the trial was at advanced stage. After hearing the Learned Council for the parties and considering the fact that the trial is in advanced stage, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to promptly produce the remaining witnesses before the court. The council further state is directed to communicate this order to the SP of the concerned district and also to direct the prosecution to ensure compliance.
Item 15, DA.15.04.2026 along with item 16.
victim को नोटिस करने बोला गया लेकिन they have refused to receive the notice.
183 का आ गया of the victim. डायरेक्ट एलिगेशन है आपके ऊपर दोनों पर. एक दोस्त है दूसरा दोस्त नहीं.
नहीं दूसरा थोड़ा सा उसमें है कंसीडर करने का कि हम दवा लेने में कोई जो दैट इज वन से ऑपरेटिंग
FIR कर.
हाँ
ठीक है.
एंड फिर रास्ते में मानसून के पास मुझे
सूरज कुमार
घर जाना है. चलो मैं घर जा रहा हूँ. सूरज के घर से मेरा घर 150 फीट की दूरी पर है. मुझे सूरज कुमार ने विकास कुमार के मोटरसाइकिल नंबर पर देखा दिया और बोला कि मैं और निशान दूसरा गाड़ी से आ रहा हूँ. पीछे पीछे पर विकास कुमार ज्ञान सरोवर होते हुए हमारे गाड़ी के जंगल ले गया और ले जाकर छोड़ दिया. पीछे से सूरज आया और चाकू दिखाकर मेरे साथ दुष्कर्म किया. उसके बाद विकास कुमार जबरदस्ती करने लगा तो मैं चिल्लाने लगा. तब और डर के हमारे अपना ही मोटरसाइकिल पर बैठाकर स्पीड में जंगल से रोड पर लाया. गोली छोड़ने के ही पहले मुझे विकास कुमार मेहन ने गिरा दिया. जो गिरा हुआ अवस्था में देखकर मुझे उठाकर इलाज के लिए नरवा हॉस्पिटल में भर्ती कराया. डॉक्टर देखा कि इस बच्चे की पैर टूटा हुआ है. पूरी हॉस्पिटल में देखकर इलाज के लिए रेफर कर दिया गया. अभी तक में इलाज तो ये कह रही कि सूरज कुमार बोला कि चलो घर छोड़ देते हैं. लेकिन विकास इसको ले वहाँ इलाज नहीं की. फिर उसके साथ सूरज कहता है दूसरा किया वहाँ भी किसी तरह का विरोध कोई लाभ नहीं. जब कह रही है कि विकास भी मेरे साथ
विरोध नहीं की ना.
हाँ
she never objected.
हाँ ऑब्जेक्टेड हम लोग से नहीं वो हल्ला की क्योंकि वो पूरे एरिया सिर्फ भारीकाली हिंदू में जाएंगे. भारीकाली के जस्ट बगल में थोड़ा झाड़ी रहती है. पूरा डेंस पॉपुलेटेड एरिया. हम दिल्ली जो है विक्टोरिया थाना से 100-150 मीटर के बगल वाला गाँव.
अभी विक्टिम 17 साल की है. ऑब्जेक्शन नहीं. ऑब्जेक्शन का क्या गलत.
नहीं
लव अफेयर का कहानी तो नहीं सुनाई. कोई लव अफेयर का कहानी सुनाई नहीं सुने
नहीं वो कह रहे हैं बगल का है,
बगल का है।
नहीं जो सूरज के साथ है, सूरज के साथ कंसल्टिंग दिख रहा है, लव अफेयर है, वो कह रहे हैं कि
कहाँ लव अफेयर है? जानना और लव अफेयर में बड़ा फर्क है।
नहीं और
पड़ोसी ये जानते हैं इसीलिए ट्रस्ट किए।
और दूसरा की
क्या स्टेज है
दो
इसका ये
दो बात
बताइए।
अभी तो कमिट हुआ, दूसरा चीज आ रहा है चाइल्ड वेलफेयर कमेटी के सामने ये बोलिए कि दोनों हमारे साथ दूसरा यहाँ से एक को बोल रहे हैं एक
दूसरा के बारे में
बोलिए उसको। हाँ और इसमें मुझे कहना है कि इसका ये लड़कों का मेडिकल नहीं हुआ जो मेडिकल प्रोविजन है 53A में DNSS में उसको भी नहीं हुआ, इसका एज को भी असेस नहीं किया गया जो ये बोलिए बस
क्या
डायरेक्टली डेथ पे गई उसको तो पैर तोड़ के बराबर
नहीं वो तो
एक्सीडेंट
नहीं हुआ था वो तो
All
एक
the
केस
learned
है।
counsels appealing, just a moment, heard the learned counsels appealing on behalf of the parties, the learned counsel for the petitioner submits that petitioner. दोनों में आप ही हैं petitioner? The learned counsel for the petitioner, ये वाला लिखिएगा, ये number 240026. Petitioner submits that the petitioner has been falsely implicated in this case and there is allegation in the FIR that the co-accused Vikas Kumar had taken the victim on his motorcycle. And the petitioner is in custody since 5/10/2025. The learned counsel for the state has opposed the prayer and has submitted that, as per the FIR, Vikas Kumar took the victim to Itkori jungle and left her, and Suraj Kumar, the petitioner hearing, came from behind and committed rape on her on the count of 9. And thereafter, Vikas Kumar also tried to commit rape on her, but when she started screaming, then Vikas Kumar took motorcycle and went towards the road. The learning counsel submits that as the victim has supported the allegation under section 183 BNSS and it is to root of class 9. After hearing the learning counsel for the parties and considering the nature of allegation which is direct against the petitioner, supported by the statement of the victim under section 183 BNSS, this court is not inclined to enlarge the petitioner on bail. It's rejected. Vikas Kumar, आप क्या same order? Vikas Kumar का लिखते हैं. The counsel for the petitioner seeks permission to withdraw this bail application. According to this, petition is dismissed as withdrawn. Common order बना दीजिएगा दोनों. ठीक है? क्या चीज़? अच्छा. Affidavit of the state is placed on the court.
Sign कर दीजिए.
File today which is taken on board.
Item 17 DA.15.04.2026.
Sorry? अच्छा.
उसको फिक्स कर दिया जाए डेट पूरे से फिक्स कर दिया
कब तक है?
Monday.
The learned counsel for the petition submits that the arguing counsel is unready. At his request, poses case on.
Serial 290 password. इसको भी रख देना.
Sorry, कौन सा?
2 और 9. Serial 2 and 9.
इस FIR से है?
No.
पासवर्ड?
हाँ password.
जो आइटम टू पासवर्ड इन्हीं के कहने पर बता 2 और 9.
अरे भाई जी. Same order कर दीजिए. Monday. Arguing counsel is unready.
From the daily list under heading for press filing, item 1, DA.15.04.2026. of 2026.
Charge sheet has been submitted.
He was caught with the victim in the Giridi bus stand. Was he caught with the victim in Giridi bus stand?
This is the police story. My case is, I have brought the girl back. But since they have lost again, we were in touch. The girl was calling me and we were talking. This was the.
You were in talking terms.
Talking terms. And since I have refused with the terms of the girl implicated.
You refused to.
She wanted to marry.
But victim wanted to marry.
But since there was an age gap, he was certainly talking terms. He was in the talking terms. The girl who used to talk. She has also.
The girl is 14 years old.
Yes, I cannot change that position. But in this case, the medical report also suggests, Madam, that.
It has come in the case ID that she was caught in the bus stand.
Yes, Madam. The police had made this story. Because I have come back with the girl. I have informed the family. वो भी बोल रही है अपने स्टेटमेंट में कि हमको लाके बस स्टैंड में छोड़ दिया, जबकि हमारे साथ दोनों हम लोग को एक साथ पुलिस ने किया. I have informed the family. I have returned.
आपका arresting कहाँ से हुआ? Where were you arrested?
I have come to
क्या भाई आपको arrest memo बना होगा ना?
ये तो airport police they have made their memo कि I was arrested from the bus. But this is a case where I have come back with the girl. गर्ल का भी 183 का स्टेटमेंट है जिसमें बोली कि हमको लाके बस स्टैंड में. अगर डायरी एक बार आ जाता है, 2-3 चीज था वो भी था. जो फैक्ट्स है उसको हम बदल नहीं सकते. जो केस है वो भी हम प्रेजेंट कर देंगे. दिस इज द केस. मेडिकल एग्जामिनेशन हुआ है गर्ल का. That suggests a lot.
Or the learned counsel submitted on behalf of the parties. The learned counsel for the petition submits that the petitioner has been falsely implicated in this case. Rather, the story is that the petitioner was having much age gap with the victim, and the victim wanted to marry him, which he refused. And the petitioner had, and as per the statement of the victim, the petitioner had dropped her in near Viridi bus stand. The petitioner is 31 years of age and the victim is 14 years of age. The petitioner is in custody since
Since 14/11.
14/11/2020. The learned counsel for the state has opposed the claim and has submitted that as per the case lodged by the father of the victim, she departed for school by school van, but ultimately did not reach the school. And one Toto driver, that is Sanjay Kati, the present petitioner, who was in regular talking term with the victim, it was alleged in the FIR that he had taken away the victim with ill intention. And ultimately the victim was caught near the bus stand along with the petitioner. And the petitioner also has criminal antecedent.
One antecedent, but that is not such type of thing. So, तारीख thing.
One antecedent statement में एक बोली है कि
Antecedent के विषय में जो आया है,
The
not similar
the
type of.
state has also submitted that the victim has supported the allegation of rape.
one antecedent में बोली है petitioner committed wrong with
She has stated that the petitioner committed wrong after hearing the learned counsel for the parties and considering the direct allegation made against the petitioner. And ultimately the petitioner was the victim and the petitioner was caught near the bus stand at DT as is happened from the victim's order by referring to paragraph 39 of the case study. This court is not inclined to enlarge the petitioner and the defense.
Item 2, BA3009 of 2026.
Also, for the petition seeks permission to withdraw this bail application, which is dismissed.
Fine.
You will not dictate my order. Simplicity withdrawn. That's all.
Item 3, BA3016 of 2026.
That's all.
Item 4, BA3022 of 2026.
That's all.
Item 5, BA3025 of 2026.
Sorry?
serial 3.
Serial 3. क्या करना है? Serial ये कौन सा serial नंबर है?
Item 5.
3 में क्या करना है? आपको क्या करना है?
सप्लीमेंट्री का 29
सेम ऑर्डर मतलब
उसमें मंडे को फिक्स किया है।
अच्छा वो जो आपने एक ऑर्डर लिया है ना द आर्गुमेंट काउंसिल इज नॉट देयर इसी में उसे टाइम मत मांगिएगा हम देंगे नहीं
case was registered in section 80 as well as 3 surplus 5 of the PLS.
Section
It's
80 is
corresponding to dowry debt 304B. The charge has been framed only under section 18. Now, my lords,
you're the husband.
yes, ma'am, she is the husband. Only against him the charge has been framed. Now, my lords, will kindly see page 20, which is the FIR. The relevant would be दिनांक so और समय so मुझे सूचना मिली कि मेरी बेटी मृत्यु फांसी लगाने के कारण हो गई है। इस सूचना पे मैं सामुदायिक के सुनाई तो देखे कि मेरी बेटी स्ट्रेचर पर मृत्यु पड़ी है। मुझे पूरे विश्वास है मैं मिलकर मेरी बेटी को जानना फांसी पर लटका कर मेरी बेटी के साथ शादी की हमेशा 2 लाख रुपए एवं एक मोटरसाइकिल बराबर मेरी बेटी से जिस कारण घटना घटी करीब 1 सप्ताह पहले मेरा दामाद मेरे घर आया तो मेरी बेटी को
Direct allegation. Within 1 year she has died
that
under
is
matrimony.
my submissions are very from the records itself. Lord's inquest report as well as the postmortem both are available before your lordship. Now they both say that V shape is there. It's because of the hand. उसमें लिखा हुआ है
बात ये सुसाइड करे
नहीं ठीक है
वो hanging से मरे she has died within 1 year of marriage in matrimonial house and there is allegation of demand of
Let's agree.
अब इसके बारे में और चार्ज सिर्फ आप ही के अगेंस्ट में फ्रेम हुआ है बाकी किसी के अगेंस्ट में फ्रेम नहीं हुआ
What I am trying to say केवल दो तीन चीजें हैं बहुत ज्यादा होगा नहीं मुझे पता है But what I am trying to say कि पहला जो पोस्टमार्टम रिपोर्ट है that clearly says that it's hanging. Now second thing my lord is that there is no body injury. There is no body injury, meaning that she hanged herself. Now there can be a situation that your lordship is saying, but my lords again coming to the investigation.
No injury except neck injury.
Yes, my lords. Only one injury that is also V-shaped. That is because of the rope, caused because of hanging. Now, my lord, during investigation, the demand of dowry, as has been mentioned in the FIR, no independent witness has supported the demand of dowry. There is no demand from my side also. Only thing is that she has died unnaturally at my place. That is there. I am not denying that. Now, my lord, during investigation, one thing has also surfaced that इनके ही केस डायरी में है कि गुप्तचर से जब संपर्क किया था तो उसका जो इंफॉर्मेशन था he says कि I was having a drinking problem and she was unhappy about this. I went out to drink and she hanged herself. उसके अलावा मेरे अगेंस्ट में कोई भी एलिगेशन
और the learned counsel is appealing on behalf of the parties. The learned counsel for the petition submits that though the petitioner is husband and the victim has died within 1 year of marriage in her matrimonial home, but the petitioner has been falsely implicated in this case. He submits that there is no ante-mortem injury on the dead body except the injury on the neck and she committed suicide. He submits that petitioner was alcoholic with which the victim was annoyed and that was the reason for committing suicide.
That is there in the investigation.
It has come in the investigation. And apart from, he has further submitted that there is no material in the entire investigation to support the claim of dowry. The learned counsel for the state has opposed the prayer and has submitted that the informant himself has stated that the petitioner used to demand dowry of rupees 2 lakhs and 1 motorcycle, and prior to the alleged date of occurrence, the petitioner had come to his house and forcibly taken the victim with him, and by leaving, he has threatened that his daughter will be killed. After hearing the learned counsel for the parties and considering the fact that the wife of the petitioner died in matrimonial house within 1 year of marriage, and there is direct allegation of demand of dowry in the FIR itself, which is lodged by the father of the victim, this court is not inclined to enlarge the petition on bail to this rejected.
Serial number 4
Item 6. पास
दे
ओवर
दीजिए अपना पास ओवर हुआ है तो अभी से क्यों नहीं?
Item 6 BA 3026 of 2026.
Counsel for the state is directed to file a counter affidavit with antecedent report, call for the case diary from the concerned court along with the statement of victim with medical examination report, and also statement recorded under section 183 BNSS. Post on 6th of May.
Appearance is Item 7 BA 3032 of 2026.
The bail application of the petitioner was made earlier in bill number 11736 of 25, which was dismissed as not pressed. Obviously directed to place this case before the Honorable Chief Justice on the administrative side for application.
Item 8 BA 3033 of 2026.
FIR was registered under section 103 charge sheet. It's certified and submitted under section 108.
Counsel for the state is directed to file counter affidavit in this case. The call for the case diary along with the alleged suicide note of the victim. And also the postmortem report. इसमें कोई FSL भी गया है? Are you sure? It was done 6,000.
Item 9 BA 3051 of 2026. Item 10 BA 3052 of 2026.
Where is the case of the co-accused, Ramesh Das? Ramesh Das is here. Sachin Kumar Das? It has been filed. It is showing that it has been filed. It is showing. देखिए तो फाइलिंग नंबर होगा शायद 6566 of 26 का स्टेटस में है. filing number is 6566 of 26. Council Wazir Mawad.
1 year.
Council for the state is directed to file contract affidavit along with criminal antecedent report of the petitioner. The office is directed to sort out the case ID along with its enclosure from the concerned court. Post this case on 12th of May.
Appearance will
ये जो दूसरा वाला केस है ना, जो आप देखे वाजिनामा में है, उसका जैसे टाइम पूरा उसको लिस्ट करा दीजिए साथ में पैक करना।
Item 11 DA.15.04.2026.
Coming for the first.
DA number 3061 of 26. Case ID has been called for with respect to the co-accused in DA number 2816 of 26, which is fixed for 3426. Post this case, tag this case along with DA number 2816 of 26 and post on 3426. Counsel for the state is directed to file a counter affidavit in this case along with criminal antecedent. उसमें केस डायरी आ गया.
Item 12 DA.3062 of 2026.
Same order? Same. Yes.
Item 13 DA.3063 of 2026.
One BA number 2756 2026
In 2807.
plus 2756.
The DA number 3063 of 26.
And 14. 13 and 14.
13 and 14 don't. Counsel for the petition submits that arising out of the same FIR. BA number 2807 of 26 and BA number 2756 of 26. The matter has been fixed on 3426 and case ID has also been called for. Counsel for the state is directed to file counter affidavit in this case along with criminal antecedent report of the petitioner. In these cases, right, post this case on 34/2026 along with BA number 2807 of 26, tag along with BA and 2756 of 26. सब tag करके उस दिन लिस्ट होना चाहिए, ठीक है? सबमिट करके स्प्रेड ऐसा नहीं.
Item 15 BA.3069 of 2026.
Allegations of complaining 8 years old daughter erosion.
It's on, file is on. What the counsel for the petitioner submits that the petitioner has been falsely implicated in this case. And he is in custody since 22/1/24. Nobody appears on behalf of the state. However, the records of the case reveal that there is direct allegation against the petitioner and the victim is just 8 years of age and the trial has already come. The improved order is dated 31/1/25, according to which out of 9 witnesses, 1 witness was examined. It appears that a few witnesses must have been examined in the meantime. The appearance report. oppose the plea by saying that trial is on. After hearing the learned counsel for the parties and considering the fact that the trial has already commenced, this court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the witnesses are promptly produced. Just as in the state is directed to ensure prompt production of witnesses. Counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution to ensure compliance. You see, under the Act, there is a mandate that you have to conclude the trial the trial has to be concluded within 1 year. Right? Within 1 year. 1 year, है ना? So that is the mandate you are bound to follow. आप विटनेस प्रोड्यूस करेंगे तो ट्रायल होगा, नहीं प्रोड्यूस करेंगे तो नहीं होगा. 5 तो विटनेस ही होता है. Right? Pokso trial will not take much time. और 1 महीना के अंदर विक्टिम को एग्जामिन करना. That is also the mandate. Victim appears to have been examined as the first witness.
Item 16, DA 3070 of 2026.
Twice the matter has been
Witness will be produced.
कौन
सी डिस्ट्रिक्ट
It's more interesting एक point of law involved है. No, it's not that cyber वाला वो चीज नहीं है. It's a personal fraud का case है. It's not that
18 lakhs rupees.
हाँ, personal fraud का. Now, the last order.
No, we have seen that. Stay, आप कहाँ केस की हैं? कहाँ का केस है? धनबाद. The counsel for the state is directed to seek instructions from the concerned SP as to why the witnesses are not being produced before the concerned.
परेशानी है. इसमें परेशानी क्या है? जो इन लोगों ने ट्रायल किया, that was an irregular. क्योंकि this is a case which is to be conducted by a special court, but the case was never conducted by a special court. The case was conducted by a magistrate to frame charges, magistrate to the witnesses were examined by the magistrate. Now, one fine day when the matter came to me, I informed them that this is wrong. So what they did was immediately the matter was transferred to the special court as it is. Now the problem would be that the part which has been done by the magistrate, now it becomes absolutely irregular.
We find it. It is irregular, so
एक report एक नहीं हाँ वो नहीं हम नहीं बोलेंगे. What is the facts of the case I'm telling? So if you launch it as
maybe that the
call for a report वो नहीं वो लोग witness तो मंगा दिए. अब now the problem would be that whether those witnesses can be looked into, because that becomes a proceedings which is not only illegal, which is irregular, which vitiates the entire.
If it is absolutely irregular, then the witnesses we produce again in the same court. होगा ना?
करना पड़ेगा.
कोर्ट की गलती से, प्रोसिक्यूशन की गलती से या कोई भी the case will not.
हमारा
करना पड़ेगा तो करेंगे. फिर क्या?
दिन का जो मेरा डिटेंशन वगैरह
आपके बैंक अकाउंट में पैसा आया है?
आया.
You have taken money in your bank account. कोई कैश ट्रांजैक्शन नहीं है और कोई आपका बिजनेस डील नहीं.
आप इसे सीखा कि पीछे हम नहीं जाएंगे.
Let us report be called for.
I report call for.
Let a report be also called for from the concerned court as to why the trial has not proceeded.
Trial has proceeded, but trial has proceeded in a wrong way.
That's right. Regarding the stage of the and also regarding the stage of the trial.
ठीक है.
फिर दोबारा विटनेस रिलीज होगा क्या? डायरेक्शन चाहिए आपको?
मेरा जो एविडेंस डिफेंस है वही खत्म हो जाएगा.
इसीलिए आपकी मर्जी है. 2 बार रिजेक्ट हो चुका है आपका ऑन मेरिट्स.
इसमें ग्राउंड के लिए हम हमारा एक ही ग्राउंड है बस और कोई ग्राउंड नहीं. कस्टडी इतना लंबा हो और कोई एक्यूज का बेल हो गया है. 24 से हम जेल में हैं और मैक्सिमम
कोई एक्यूज का तो बेल हो गया है लेकिन आप तो आपका तो 2 बार रिजेक्टेड है.
2 बार रिजेक्टेड है. अब इतने कस्टडी का पीरियड एक है वो एक कस्टडी का पीरियड
हमको भी रिपोर्ट एसपी बनाना है।
आपको एसपी से रिपोर्ट लाना है
क्यों नहीं एविडेंस?
क्योंकि लास्ट टाइम जब इनका बेल रिजेक्ट हुआ था देयर इज अ डायरेक्शन टू एक्सपीडिशियस ट्रायल
वही उसी को हम अभी
देयर इज अ डायरेक्शन टू एक्सपीडिशियस ट्रायल उसके बाद विटनेस नहीं प्रोड्यूस हो तो इसका एडवांटेज इनको थोड़ी मिलेगा आपको जो करना है करिए कोर्ट में भाई योर एपीपी इज देयर ही नोज व्हाट इज टू बी डन दोबारा प्रोड्यूस करना है नहीं करना है क्या करना है वो तो वो जानेंगे ना बट ही हैज टू टेक स्टेप्स अगर ये बोल रही है सही है तो उसका जो भी एज पर लॉ है वो करना पड़ेगा ना इसीलिए एसपी का
उसका एक चीज था उसमें उस दौरान
पोस्ट ऑन पेल
6-7 महीने का डायरेक्शन था 6-7 महीने का
वो तो आपने तो नहीं बोला लेकिन मैंने
तब मेरा
12 मई को
Under heading for admission, item 17, BA 1183 of 2025.
आगे
एक दो दिन समय दीजिए डेली के क्या
मंडे का
हम मंडे
at the request of the state post this case on Tuesday in the supplementary court. ठीक है
Item 18, BA 199 of 2026.
Last occasion was medical report is a facial report was
और victim और FSL वो नहीं कराया number of witnesses examined दो witness examine हो चुके हैं
victim and informant has been examined who has declared hostile.
both victim and informant both
Yes, supplementary affidavit page number 5.
मेडिकल में क्या है मैडम
Supplementary.
ट्रायल आपको एक्सपीडिट कराना डायरेक्ट एलिगेशन है ना
जिसको करेक्ट डिपोजिशन इसका सर टोटली डिफरेंट है एक बार देख लीजिए पर पेज नंबर 5 सप्लीमेंट्री और डेटेड 13/3/26
victim is what is the age 6 to 7 years
10 years
नहीं 6 to medical report is 6 to 7 years 6 से 7 साल की बच्ची क्या बोला आपका क्या हॉस्टाइल और क्या नॉन हॉस्टाइल
एक बार देख लिया जाए
देख लेना आपका ट्रायल एक्सप्लेन
स्टोरी
कराना
है
है
एक बार देख लिया जाए
ठीक है स्टोरी सुन लेना
PW1 is the victim and PW2 is the informant. Who is the
Informant
mother
one.
of mother. Their details.
कहाँ है आपका ये कहाँ लगा
Supplementary. File 13/3/26. Page number 5. The deposition of victim. Page number 5. May I read you? संजय मुंडा मेरे घर आया था मेरी मम्मी से माचिस मांग रहा था जब मेरी मम्मी संजय को माचिस नहीं दी तो वह मेरी मम्मी को गाली गलौज में झगड़ा करने लगा इसी बात को लेकर मेरी मम्मी यह केस दर्ज कराई केस दर्ज होने के बाद मैं न्यायालय में धारा 183 दर्ज कराई जिस पर मेरा हस्ताक्षर है पहचानती हूँ मैं न्यायालय में मौजूद संजय मुंडा को पहचानती हूँ संजय मुंडा मेरे चचेरे मामा PW2 यूनिवर्सिटी नेक्स्ट पेज यूनिवर्सिटी पेज नंबर 6 माचिस के लिए झगड़ा पेज नंबर 6 मैं रेगुलर इसी वर्ष घटना फागुन चैत महीना का है, लगभग 8 महीना पहले का है। शाम 7 बजे बज रहा था। शादी का कार्ड बांटने के लिए मेरा भाई राजू आया था, उसी के साथ संजय आया था। संजय मुझसे माचिस मांगने लगा, फिर मैं उसे माचिस नहीं दी तो वह मेरे साथ गाली गलौज करने लगा। इसी बात को लेकर मैं थाना गई। थाना वाले पता नहीं क्या क्या लिखे और मुझे पढ़कर नहीं सुनाया था। इसके बाद मुझे हस्ताक्षर करने के लिए कहे। प्राथमिकी आवेदन पर मेरा ही हस्ताक्षर है। टोटली एफआईआर जो है सो डिफरेंट इनका हैंडराइटिंग भी इनसे ओनली सिग्नेचर करा लिया गया। क्या लिखे सुन पढ़ कर बताए। इन्फॉर्मेट का जो ये पिटिशनर है से कजन ब्रदर है। कार्ड बांटने के लिए है।
आपको क्या बोलना है? कौन आई विटनेस? मदर वो तो हॉस्टाइल और वो बाकी दोनों they had seen the occurrence.
कैसे वो pregnancy para 18 of case diary.
फाइल नहीं है सर एजुकेशन इन्फॉर्मेट मिलते पीडब्ल्यू पुलिस
नंबर
51.
साक्षी धर्मी देवी ये कौन
Father है राजू मुंडा and maternal uncle. Times para 15 to 18, 15. What time?
Informant is the mother of
लाल मोहन कौन है?
Maternal uncle. राजू मुंडा भी है maternal uncle. 16.
Or the learned counsel superior on behalf of the parties, the learned counsel for the petitioner has submitted that though there is direct allegation against the petitioner in the FIR lodged by the mother of the victim, but the victim as well as the mother has turned hostile. And he has further submitted that their evidence revealed that there was a fight in connection with giving matchbox. The learned counsel for the state has submitted that the accused is the cousin brother of the informant and the victim is 6 to 7 years of age as per the medical report. She has also submitted that the father of the victim and other witnesses, including the maternal uncle, had supported the case of the prosecution as recorded, as per the statement recorded in the case diary, whereby when the victim was gone missing, they searched for her and upon alarm raised by her, she could be traced from the jungle along with the petitioner. She has submitted that the trial can be expedited. After hearing the learned counsel for the parties and considering the allegation made against the petitioner, and there are other witnesses supporting the case of the prosecution, including the father of the victim, and the trial is on. Under such circumstances, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced so that the trial is concluded at the earliest. Also, further, state is directed to communicate this order.
Next date is
Sorry.
8/5/26.
Counsel for the petition has submitted that the next date in the trial is 8/5/2026. Counsel for the state submits that on the next date the witness shall be produced. इतना सारा है किसी को तो produce
एक साल कस्टडी में
कोई बात नहीं हो जाता ट्राई खत्म हो जाता बाप का गवाही कराइए सबसे इम्पोर्टेंट गवाह वही है हमको नहीं करवाना।
अब तो मदर का हो गया, जो इन्फॉर्मेट विक्टिम सब चीज बोल रहा है कि माचिस के लिए झगड़ा हुआ था।
मदर का भाई है ना
जी,
मदर का भाई है ना एक्यूज्ड,
मदर का चचेरा हुआ है।
नहीं समझ आई आपको बात?
प्रीवियस इनिमिटी करनी होती है।
Item 19, DA 912 of 2026.
This is possible counter evidence does not fight against it.
Yes, what is it?
Stated by the para stated that this person has committed the murder of the daughter of the informant. The petitioner has strangulated the deceased daughter with the help of the damsha and hang her in bathroom. But in the interim order, it has come.
You were seen fleeing away, right?
Yes, Mother, this is a case of last scene. But in the interim order, this is the allegation. Witnesses is stated. But the doctor who conducted the postmortem report shows cause of death with asphyxia. Not a case of strangulation. This is the asphyxia. She herself committed suicide. As because there was a love affair between the parties going on, the daughter of the informant and the petitioner. And in this case, also the charge has already been framed, but till today not a single witness examined and is in custody since 6 Spring 2025.
Age of the victim?
The age of, she is the major part. It has come in the FIR. Being 20 years. 20 years.
लव अफेयर का कहानी कहाँ से हुई?
ये उसी के ऊपर में आया हो तो उसमें
There is a story of love affair.
मुझे तो नहीं पता है कि दिनांक पुत्री को कमला अधिकारी के मृत्यु हुआ 9-10 बजे रात में पुत्री को मोबाइल फोन में बात कर रहा था, दोनों बात करते थे, ऑलवेज दे आर टॉकिंग prior to the incident they were talking.
Where is the state? Where is it? Also. His daddy's का कहाँ? अच्छा आगे.
Item 20, DA.15.04.2026.
कुछ समय दे दिए कोर्ट का टाइम कुछ डिपोजिशन इसको हुआ ही हुआ कुछ नोट्स
आप फिर से दोबारा मूव कर लीजिए. जब आपको बेल चाहिए ही नहीं तो फिर आपको क्यों करना है? आपको जब बेल करना ही नहीं है तो फिर क्यों करना है? 2 विटनेस एग्जामिन हो ही चुके हैं.
Yes, sir. Who is not supported in this case?
5 बाकी हैं.
Who is not supported in this case? उसी की सप्लीमेंट्री फाइल करने के लिए समय एक और इम्पोर्टेंट केस गवाही जो समय देते हैं इसके अंदर
हम समय नहीं देते हैं. आप गलत टाइम नहीं है. Fractured ribs. बुरा हाल है.
Reason has not been assigned why he has committed this. FIR read करते हैं.
She is alcoholic. She was alcoholic.
ऐसा
ऐसा आप कह रहे हैं.
Yes, yes.
पोस्टमार्टम रिपोर्ट में आया है alcoholic.
मेरे पास
कौन है आप? Who are you?
husband
कुछ नहीं करना.
थोड़ा सा समय दे दिया जाता है इसको हम सब
कोई काम नहीं है. ट्रायल आपका एक्सपीडाइट करा देते हैं. बाकी सब विटनेसेस सब आप सब एग्जामिन कराएं. नेक्स्ट डेट बताइए. एक के बाद एक डेट लीजिए. सारे विटनेसेस एग्जामिन करें. फाउंड डेड इन मैट्रिमोनियल हाउस.
Yes.
With multiple injuries.
With
multiple injuries. नहीं 12 years का तो कहानी को समझ. With multiple injuries.
वैसे FIR में कुछ नहीं है.
नहीं
एक बार पढ़ दे.
पोस्टमार्टम रिपोर्ट में ये गलत लिखा है क्या? Cause of death is due to traumatic shock leading to hemorrhage in thoracic cavity due to trauma to lungs or fractured ribs. गलत लिखा है तो बताइए हम लोग. ये आया है ना किस डायरी का है. ठीक है. अगर
घटना होने का कुछ तो कारण होना चाहिए. कारण नहीं.
कारण होना चाहिए. वायलेंट नहीं हो सकता है. घटना होने का कुछ कारण होना चाहिए. लेकिन वायलेंट नहीं हो सकता. हस्बैंड टुवर्ड्स सिस्टम violent to such an extent that the lips were also broken. For the learned counsel appearing on behalf of the parties. The learned counsel for the petition has submitted that the petition has been falsely implicated in this case and the marriage had happened 12 years prior to the incident. However, the trial is.
No eyewitness in this case.
He has also submitted that there is no eyewitness to the arrest of
Reason has not been assigned. Why?
and the reason for the incident has not been assigned. The counsel for the state has opposed the prayer and has submitted that the victim was found dead in a matrimonial home with multiple injuries, including fractured ribs. And in the case diary, the witnesses have fully supported the case.
No. Witness has been examined who has not supported.
Examine का बात नहीं करूँ. Otherwise, in the case diary,
After charge, Your Worship, two witnesses.
it is the counsel for the petitioner has submitted that after charge, 2 witnesses have been examined, but they have not supported the prosecution case, and they have been declared hostile.
Not supported, Your Worship. Hostile.
But they are not being declared hostile. After hearing the counsel for the parties and considering the fact that the wife of the petitioner was found dead in her matrimonial home with multiple injuries, the petitioner, this court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court so that
Next date is Your Worship, 11/5/26.
at today the counsel for the petitioner submits that the next date in the trial is 11/5/26. कोई ना कोई witness आना चाहिए आपको, communicate कर दीजिए SP और director prosecution.
Item 21, BA 1825 of 2026. Item 22, BA 2203 of 2026.
In case of the victim, and both married together, victim is also dated. I have also annexed the page 18, the school living certificate of the victim. Date of birth is 1/1/2007.
Allegation क्या है?
एलिगेशन ये है कि
FIR पढ़ी?
हाँ पेज पे
नाम मत बताइए.
हाँ नाबालिग बच्ची को वहाँ से सादा सूचित करना कि मैं सचेतन कैसा बीते कल दिनांक 24 मेरे नाबालिग सचेतन उन्हें इतना तो अब घर से निकली पड़ोस के अपनी सहेली क्या है तुरंत वापस है जब 2-3 घंटा बीत जाने के बाद घर गई तो काफी खोजबीन किया तब मालक हुआ ने मुझे बताया कि एक अज्ञात व्यक्ति के साथ मोटरसाइकिल में दिल्ली से पास की पार्क में जाते हुए घर में खोजबीन कर रही पाई कि नर्सिंग की बैग से लवी कुमार पिटिशन पिता बाबू को रहता और बेटा आधार कार्ड में रखा था जो फोटो जिसके हाथ में देखी तब मुझे पुलिस पार्टी की मुझे लेकर दी जिसकी भी बाधा
इस डायरी देखना पड़ेगा.
और डायरी डॉक्टर कॉल सी हमने इलेक्शन लगाए तो शादी भी कर ली है नोटिस प्रोसेस में
कब किए? बाद में किए? कब किए? FIR के बाद किए?
हाँ एफआईआर
बाद में.
एफआईआर हुआ 4 बार एफआईआर हुआ है 7/12/25 को हम लोग शादी के 6/12/25 4/12/25 मंदिर में शादी
और FIR कब का है?
एफआईआर है 7/12/25
और इन्फॉर्मेंट है. इन्फॉर्मेंट कौन है? लेकिन
उनकी नाम विक्टिम की नाम
और अभी विक्टिम कहाँ है अभी?
अभी तो विक्टिम को उनके पास भेज दिया गया तो कस्टडी में तो मेरे साथ रही है बहुत दिन रही है.
The petition is directed to impeach the victim as opposite party number 2 in the present case. The counsel for the state is directed to make to be the petitioner is further the counsel for the state is directed to get the notice served through the concerned police station. कहाँ की है victim?
विक्टिम है राजमहल है तो तिब्बती की रहने वाली लेकिन वो नानी की रहती थी राजमहल.
जो भी उनका present address तो आपको पता होगा ना?
हाँ राजमहल की.
In keep at her present and correct address. And file refusal for service of notice upon the victim to the concerned police station. The counsel for the state is directed to file affidavit regarding service of notice upon the victim. Stage क्या है crime? Stage.
स्टेज
इसका चार्जशीट सबमिट हो गया, केस इज कमिटेड टू द कोर्ट ऑफ रेफरेंस।
विक्टिम का 183 का
183 हुआ, बट आई हैव नॉट कॉपी ऑफ द 183।
the office is directed to call for the statement of the victim recorded under section 183 BNSS. Let this order be communicated through fax to the concerned. आप affidavit फाइल करिए सर।
Also, whether the victim be added as an OP number 2 as
OP number 2
by name or by as accept, because we cannot add her by name. That will be difficult. We have to usage her name. In such type of cases, generally the state used to issue notice through submitting to the police of the
okay,
area.
straight away यहाँ पे नहीं होता, add नहीं करते पाएंगे।
Adding.
ठीक है, ऐसे सो the state is directed to the council for this state is directed to take steps so that the victim in the present case is served notice through the superintendent of police of the concerned district. The council for the state is directed to seek instructions and file supplementary affidavit. File an affidavit regarding service of notice. The
SSP or through SP.
The service report should be filed latest by 4th May. That would our time. By 8th May. Post on 12th May. About 183 BNSS custody. And also the state of the case. It will be stated.
Item 23, DA.15.04.2026.
And the main offense is under section 109 as per the allegation, due to non-fulfillment of additional demand of dowry as couple took place, and the petitioner assaulted his mother-in-law by fraud. So, the daughter of the informant, the statement has been recorded by the IO during investigation, in which he categorically stated that no demand has ever been made by this petitioner. Only कि डांटते फटकारते रहती थी, इसीलिए इस पर हमेशा petitioner.
अभी मरा है कि नहीं मरा?
कोई नहीं मरा. और nature of injury भी नहीं है, hard and blunt object.
Who is the victim?
Victim is the mother-in-law.
Mother-in-law of the petitioner.
Petitioner. जो उसकी डॉटर है उनका स्टेटमेंट आया है डायरी में।
आप हस्बैंड है
विक्टिम के हम सन दादा।
अच्छा अच्छा। FIR किसने की? विक्टिम।
फादर इन लॉ की उसके हस्बैंड।
कोई इंजरी नहीं है।
इंजरी है?
विक्टिम का कोई इंजरी नहीं है।
विक्टिम को इंजरी हुआ हार्ट एंड ब्लड ऑफ द नेचर ऑफ इंजरी है।
Where is the injury?
CD is subject in para 50 there is injury.
Para
50 5.
Hard and blunt.
जी तलवार का कोई नहीं है।
Para 34 is the statement of injured victim.
Para
34. 1 to 8.
Ready? ये जख्मी तो इसका मैच नहीं कर रहा इंजरी, तलवार पैर में बार बार मारा।
और 57 देखा है इनकी बेटी का।
one criminal accident regarding 498
उसमें कंप्रोमाइज के आधार पे वो
earlier lost
कस्टडी कब से?
6-4 कस्टडी है 12/11/2025। इसमें चार्ज फ्रेम हो गया 6/4/2026। अभी से चार्ज
About the learned counsels appearing on behalf of the parties, the learned counsel for the petition submits that in the present case, victim is the mother-in-law of the petitioner, and the FIR was lodged by his father-in-law by alleging that the victim was assaulted by the petitioner by sharp cutting sword. And there is allegation of demand of dowry. The learned counsel submits that the statement of the victim has been recorded in the case diary, and as per the case diary, she has supported the allegation of injury caused by sharp weapon. However, the medical examination report revealed that she suffered such an injury on account of hard and blunt substance. The petitioner is in custody since 12/11/25 and the charge has already been framed on 6/4/2026. He has also submitted that the wife of the petitioner has not supported the allegation of demand of dowry as per the statement. ये बात सही है लास्ट वाले?
Manju Devi का statement 161 पैरा 57 में आया हुआ केस में।
हाँ लेकिन इन्होंने पैरा 60
57
she has not supported the allegation of demand. डिमांड का तो कुछ नहीं है लेकिन टॉर्चर का है। The learned counsel for the state has submitted that the petitioner has a criminal antecedent under section 498A of the IPC, and though the wife of the petitioner has not made any allegation so far as demand of dowry is concerned, but she has stated that the petitioner used to assault her. To this, counsel for the petitioner submits that the case under section 498A ended in a compromise.
Para 16
He refers to para 16 of the Bail Act. After hearing the learned counsel for the parties and considering the opposing facts and circumstances, and the custody of the petitioner since 12/11/2025, the petitioner is directed to be embarked.
Item 24, DA.15.04.2026.
The officers are civil officers LS 6496 and other 9 sections of the BNS along with the sections of POSO Act. But on the charge sheet in this case is submitted only for the office under section 85 of the BNS corresponding to 498A, section 3/4 of the Dowry Prohibition Act, and section 9 in charge sheet is like the Bal Vivah Adhiniam, and it would be Child Marriage Estate Act. Child Marriage Estate Act. Provisions are also because I have checked out it in online. It's a child, section 9 of the Child Marriage Estate Act. And last week in January was for the statement of the victim in 183 is also there. I have just checked out the January.
What was the age of the victim on the date of occurrence?
Lordship, she says that the occurrence was taken place in 2024, but the first information report is lodged in the year February 2026. That she was subsequently married. In 183 statement, she only said that she married with the petitioner and she was tortured for the demand of dowry. That
what was her age on the date of occurrence?
17 years, as per medical report and as per the Jharkhand State Academic Council, secondary examination. 2008 date of birth.
Allegations are very serious.
Allegations, those allegations have been made, but if our statement has said 183 total brushed aside the allegation, and in course of investigation, the offences have not been found as per the alleged offences. It is only under section.
Charge has been framed.
Charge sheet has been submitted and the cognizance has been taken. And they, from the online I have just checked out and also
charge किसमें frame हुआ है ये important है. charge sheet किसमें जमा हुआ है ये important.
हाँ इसी important, but the case is pending before the ACGM, Additional Chief Judicial Magistrate. The matter was remanded to the Additional Chief Judicial Magistrate since the offences, all the offences are the magistrate trial. And her statement.
No, I'm not getting it. आपका submission आप कैसे कहाँ से आप बोल रहे हैं? Supplementary file करिए.
चार्जशीट का ये चार्जशीट का कॉपी होता है और इनकी स्टेटमेंट भी है 183 का स्टेटमेंट भी है विक्टिम का 183 स्टेटमेंट है लास्ट पेज ऑफ द केस डायरी.
Victim को notice कर. The state is directed to serve notice upon the victim through the SP of the concerned district and file an affidavit regarding service of notice. Who is this case on? The affidavit of service should be filed by 8th of May, post on 12th of May.
Item 25, DT.15.04.2026.
Once rejected on 2/5/2020. DA number 549 of 2024. The offence under section 302 and 34 of the IPC. Now, I have also brought on record by way of supplementary evidence that several witnesses have already been examined. Amongst them, 5 have been declared hostile. Now, the examination of the witnesses started. The first witness was examined in February 2022, 9 February, and the last witness, 7, was examined so far on 21/1/2025. Thereafter, the prosecution did not examine the other witnesses, remaining witnesses.
How many witnesses are remaining?
I have not mentioned. Out of 13, 7 witnesses have been examined. 5 have been declared hostile. Even the informant, father of the deceased, PW7, PW6.
So after trial is delayed.
That is the reason I have only argued about the stage of this case. I am not said in
Heard the learned counsel's opinion on behalf of the
I am in
parties.
custody for more than
The learned counsel for the petition submits that the petitioner is in custody since
8th January 2023.
since 8/1/2023.
2023.
He has further submitted that out of 13 witnesses, out of 13 charge sheeted witnesses, 9 witnesses have been examined, and a couple of them, including the informant, has done hostile.
informant has not been hostile, but these would not fail to support the.
Just and a couple of witnesses have not fully supported the prosecution case. The learned counsel, he has submitted that the bail application of the petitioner was earlier rejected by order dated 2/5/2024 in DA number 559 of 2024. The learned counsel for the state has opposed the bail and has submitted that there is direct allegation against the petitioner. However, he submits that the trial can be expedited. After hearing the learned counsel for the parties and considering the fact that the bail application of the petitioner was rejected on merits earlier, and the trial is at advanced stage, this court is not inclined to enlarge the petitioner on bail. However, the state is directed that the witnesses be prompted, that the
Only
remaining
the official
witnesses,
witnesses are there.
yes, the apparently only official witnesses are remaining to be examined. The state is directed to ensure that the witnesses are promptly produced before the court. Next date कब है? The counsel for the state is directed to communicate this order to the superintendent of police of the concerned district and also to the director of the school. वो लोग अपने प्रोड्यूस करेंगे आप अपने प्रोड्यूस करेंगे नहीं एग्जामिन हो रहे हैं हमको पता चल रहा है हम लोग फीडबैक ले रहे हैं बिकॉज दे कैन नॉट पुट एनीबॉडी बिहाइंड बार एंड नॉट प्रोड्यूस ऑफिशियल विटनेस प्रोड्यूस करना है तो फिर कोई रीजन नहीं होता है और रादर फॉलो अप ले लिया करिए क्योंकि जब आएगा दोबारा तब आप ही को खड़ा होना पड़ेगा
Item 26 BA 2521 of 2026.
Initially, I have what under section 87 of the BNS. May I read that under page 30. So मैं निवेदन है कि मैं स्वयं का रहने वाला हूँ। डेट है 30/10/2025 को सुबह 4 बजे मेरी नाबालिग पुत्री स्वयं पहनी हुई थी। शौच के लिए बाहर उसी समय से गायब है। हम लोगों ने उनकी खोजबीन शुरू की। उसी दिन लगभग 5 बजे मेरी बेटी ने मोबाइल नंबर में फोन किया कि मनोज वर्मा दिस पिटिशनर पिता स्वयं जबरन बहला फुसला कर भगा लाया है। जबरन शादी करने मांग में सिंदूर डालने का प्रयास कर रहा है। आगे की पड़ताल मुझे पता चला कि जो the victim is about 90 to 20 feet. This from the certificate, school certificate. That is already in case diary. I have mentioned in para 6 of my petition. The date of birth is.
ठीक है वो तो पॉक्सो में तो केस ही रजिस्टर नहीं हुआ।
हाँ नहीं
पॉक्सो में केस रजिस्टर नहीं।
उसके बाद मेडिकल में कोई साइन ऑफ लेट नहीं। मेडिकल आया उसमें कुछ नहीं। तीसरी बात है 43 में भी लिखती है पेज 43 ऑफ केस डायरी में कि इनके अलावा कोई नहीं थे और मोटरसाइकिल से किडनैपिंग नहीं हो सकता है। आज क्या पहले भी नहीं होता था, आज भी नहीं था। मीनिंग देयर बाय बोथ पार्टी लव है, बोथ है ट्रेवल टू एच। 3 दिन बाद एफआईआर हुआ। 31 का घटना है 2/11 को। फादर बोलते हैं कि दिन भर उसके साथ 43 में ऑलरेडी मेंशन किए वो आया है, रिस्टेटमेंट हुआ है लेडीज का। और ये फर्स्ट स्टेटमेंट रिस्टेटमेंट में बोलती है कि विनोद अकेले था।
दो अन्य भी थे शादी के समय।
लेकिन जो उसमें उसके बाद मेडिकल सजेस्ट नहीं करता है कि एनी साइन ऑफ
23 में बोलती है कि केवल अकेले था।
कंट्राडिक्ट करती है दोनों भाषा की टू ईच अदर। अच्छा इसमें है जो ये नो साइन ऑफ रेप है, मतलब कुड नॉट बी असर्टेड। और दूसरी बात है एक बार मेडिकल देखिए
सुबह 4 बजे से शाम 5 बजे तक
साथ रही लेकिन कहीं को ऑब्जेक्शन नहीं किया, अकेले साथ।
हल्ला हो गया तो इसीलिए इस तरह करते हैं।
चार्जशीट फाइल हुआ है लिखे गए।
दोनों साथ घूमी फिर लौट के चल आए। जब पता चला कि वो लिखी हुई है कि वो पहले से शादीशुदा है, जब ये पता चला तो ये केस कर दिया।
एक एंटीसीडेंट भी है पहले भी इसी तरह के कांड।
अब दूसरा चैप्टर
366 विवादित भी है।
Petitioner is married.
हाँ लिखी हुई है, हम नहीं जानते।
आपको नहीं पता है? Petitioner का पैमिकार है?
हम पूछ नहीं पाए, पूछ
नहीं पाए मतलब क्या? इसीलिए तो वो जो ऑर्डर होता था ना कि पैमिकार का सारा डिटेल लिखिए, वो सही ऑर्डर।
जो नहीं है हम समझ के सब
नहीं है।
मान लिया जाए हम बोलते हैं
कोई चीज आपके खिलाफ बात होगा तो आपसे पूछेंगे तो बोलेंगे हम नहीं जानते और सारा कहानी जानते।
नहीं पूछ पाए उसका।
विक्टिम टेंडर रेंज में है तो
वो 20 साल की है।
17 साल।
मैरिड कहाँ से है? मैरिड है कहाँ से है? कहाँ से बोल? मैरिड है।
वो FIR में लिखा हुआ है।
FIR नहीं है।
उसके बाद हुजूर ये है कि 20 साल की है, वो डेट ऑफ बर्थ लगा हुआ है।
The hymen was found on. Yes. Medical report.
इसमें भी तो 183 में भी बयान दी है।
नो इंजरी सीन।
नहीं आप
बाद में पता चला कि मनोज वर्मा शादीशुदा व्यक्ति है।
Hymen slightly torn.
ये 411 वाला जो
मेडिकल का ही
हाँ उसको छोड़ देते हैं।
On internal examination, no injury seen.
On external examination, no injury seen. Developed. On internal examination, no injury seen. No foreign pulse hair seen. No semen found. Humans seen क्या है?
Slightly torn. और डलर है काउंसिल से पेरी और हाइमन स्लाइटली।
और उसके बाद हुजूर है कि नो
तो आप हम लोग मेडिकल रिपोर्ट तो पूरा ही पढ़ा।
एक बार ओपिनियन रखा।
he was married or not married?
183 का बयान में है।
Certainly I'm not.
लड़की
वो लड़की बताई है, आरोप लगाई है, लेकिन
आपको नहीं पता। You are not aware.
I am not aware कि whether he is married.
लिखे भी नहीं है that he is not married. पिटीशन में तो नहीं लिखे होंगे naturally because you are not married.
लेकिन वो जो यहाँ जो मेडिकल में ओपिनियन अकॉर्डिंग टू डिफिकल्ट टू से वेदर सेक्सुअल असॉल्ट हैज बीन और नॉट।
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submit that the petitioner has been falsely implicated in this case, and the
एक बार पता लगा ले मेरे
and the petitioner was in love affair with the victim, who was 19 years of age at the time of occurrence. The learned counsel submits that there is delay in filing the FIR by 3 days. Initially, the victim was found missing.
31 के शाम को फोन करके बताई, लेकिन 31 को थाना नहीं।
Initially, the victim was found missing, and on the suspicion, the petitioner was made accused in the FIR. The learned counsel for the state, he has also submitted that there is no sign of rape in the medical examination of the victim. The learned counsel for the state has opposed the prayer and has submitted that the victim had supported the allegation under section 183 BNSS, and the petitioner is a married person who has taken advantage of the tender age of the victim and had taken away and forcibly
She left out house from
and and had taken away the victim. He has also submitted that, as per the medical report, Hymen was found wrong. After hearing the valid counsel for the parties and considering the direct allegation against the petitioner, supported by the statement of the victim under section 183 BNSS, this court is not inclined to enlarge the petitioner on bail henceforth.
Passover case from Delhi list, item 4, VA 3022 of 2026.
This case is major allegation section 101 case corresponding section 304 of the IPC. The petitioner is the son-in-law of the deceased person, and from the result of the FIR, there is no motive and intention has been given in the FIR. And all of a sudden, he is stating that informant and the deceased were sleeping in the room, and very surprisingly, the door was not closed, and the petitioner has entered into the house and entered into the room at 10 p.m. and stabbed the sword.
The mobile was recovered from your possession?
Only for mobile has been recovered from
How
the
the mobile has come
sword,
to you?
and the sword has been recovered from the possession of another accused whose name has not come in the FIR. And the mobile which was recovered from me, it is stating that the mobile belongs to my wife. Redmi.
Mobile belongs to your wife.
Yes,
Come in
yes.
the investigation.
It has come in the
Counsel for the state is directed to file counter affidavit in this case, along with the injury report. The office is directed to call for the case diary from the concerned court, along with the injury report of the victim, and also the details regarding the seized mobile and SIM from the possession of the petitioner.
SIM has been not recovered, only for mobile. Because it has come in the immune order.
कोई बात नहीं, वो बताएंगे ना, मोबाइल बिना सिम के तो नहीं होगा, the report will come. Post on 12th May.
Item 9, VA 3051 of 2026.
She is also pregnant. 15 years. Pregnancy to है.
But there is no discussion in order में pregnancy is related with regards to medical.
She's not pregnant.
It was alleged that she was pregnant, but medical examination कुछ
आपको पता होगा ना? You must be knowing that she was pregnant or not.
काउंट कर लो मैं प्रेगनेंसी का 8 टेस्ट हुआ है.
She was found pregnant.
Yes.
Heard the learned counsel appearing on behalf of the parties. The counsel for the petition submits that the petitioner was falsely implicated in this case. And is in custody since
custody से और 28 से
28 से
एक कोई सर्विस
also for the state has opposed the prayer and has referred to the counter affidavit and has submitted that the victim was found victim over aged
is
15 years 6 months
Yes.
on the date of occurrence was found pregnant and had supported the prosecution case in a statement recorded under section 183 of DNS. That means that there is direct allegation against the petitioner.
So my submissions will be added.
हाँ बताइए क्या submission है?
Yes, so they were already in telephonic contact with us. And there is marginal difference in their age. She was 16 years old and he was 19 years old. 18 years old at the time.
The counsel for the petitioner has submitted that the petitioner and the victim were in talking terms and there is marginal difference in the age.
There is a judgment S 2026 SCC online SC 40 in which your upper margin will be senior. So she was 16, maybe.
There was love affair between the two.
It was shown that they were earlier in talking terms.
The learned counsel has submitted that अपर मार्जिन मतलब कौन सा कितना मार्जिन हो जाएगा आपके अनुसार 15 साल में 2 3 साल 4 साल के होते हैं
2 साल
तो भी तो 17 साल तो भी 17 years आप जो 19 years अपने एज लिखा है उसका कोई डॉक्यूमेंट लगाएं कहाँ से लिखते हैं 19 years age so where are you writing after hearing the learned counsel for the parties and considering the fact that the victim was 15 years 6 months and 1 day on the date of occurrence and there is direct allegation against the petitioner and she also became pregnant. This court is not inclined to enlarge the petition on bail against her.
Also, case item 19, DA 912 of 2026.
Are you there in this case? Read the FIR, please.
Yes, 14.
पढ़िए FIR पढ़िए.
जिला के निवासी कुमार उम्र करीब 22 वर्ष 10 से साफी नर्सिंग लाइन थाना मुफस्सिल जिला गिरडी के द्वारा मोबाइल नंबर 77 से मेरे पुत्र कुमार उम्र 20 वर्ष के मोबाइल नंबर 77 पर हमेशा कॉल करके परेशान करते था और पढ़ाई करने जाती थी रास्ते में रोककर शादी का करने का धमकी देता था दिनांक 12/2/2025 को मेरे पुत्र द्वारा मुझे एवं मेरे पति को बताया था दिनांक 17/2/2025 को मेरे पुत्री दोस्त की बातें अपने कमरे में पढ़ाई कर इसी बीच विपुल कुमार ने लगभग 9-10 बजे रात में पुत्री के मोबाइल में फोन करा था तो जो कि मेरा साला का बेटा विकास कुमार ने सुना कुछ देर के बाद दोनों खाना खाकर अपना कमरा में जाकर सो गए दिनांक 18/2/25 को सुबह लगभग 4:35 बजे मेरा साला का बेटा विकास कुमार पेशाब करने उठा तो देखा कि विपुल कुमार घर से निकलकर भाग रहा है तो विकास कुमार के द्वारा पकड़ने का प्रयास किया गया लेकिन अंधेरा रहने के कारण भाग गया विपुल कुमार रात में कब मेरा घर आया हम लोग को पता नहीं चला तब विकास कुमार घर में जाकर देखा तो देवी कुमारी को अपने कमरा में नहीं देखा और बाथरूम में कमरा में गया जहां लोहे के पाइप में गमछा से देवी कुमारी को लटका हुआ है मुझे पूर्ण विश्वास है कि देवी कुमारी को विपुल कुमार द्वारा जान मारकर गला में गमछा This is the allegation, but in the MP model it has come cause of death is asphyxia, and there was a
Asphyxia means what?
asphyxia due to hanging. मार के अगर गमछा से मारेगा तो स्ट्रैंगुलेशन का केस है। गमछा से ऐसे मारते हैं तो
strangulation is not asphyxia.
But
Strangulation is not asphyxia according to you.
Yes, my lord, but the ligature mark was also found. Ligature mark was also found around the neck, which shows the in the
medical report.
It has not been stated by the
Postmortem report.
The state has not highly counter affidavit, but not stated about the postmortem. When the impugn order also it has come in the asphyxia. It has also come in the case counter affidavit also at para 11.
Case diary का वो है पोस्टमार्टम रिपोर्ट
है पोस्टमार्टम है
केस डायरी में है नहीं कहाँ से आया कोर्ट से आएगा Counsel for the state has submitted that case diary has been received but it does not contain the postmortem report. Office is directed to call for the postmortem report as well as the inquest report of the victim from the concerned court. दोनों मिल जाएगा हम लोग को वहाँ से. The case diary be submitted to the court. आप जमा कर दीजिए. Post on 5th May. 5 May. आप पैराग्राफ मार्क कर दीजिए बाकी है
काउंटर में भी आया हुआ है लॉ का ऑर्डरेशन का है लॉ ऑर्डरेशन एट द टाइम ऑफ ऑकरेंस 17 को 18 they were talking they are in talking terms
so immediately before the occurrence you were talking and then you were seen at the place of occurrence and she was found dead.
Seen by the Vikas. This is the case of the last sale also. No one seemed to committed murder of the deceased. There is no eye.
Possible case item 21 DA.15.04.2026.
Yes.
In this case, by registered under section 64, subsection 1 of the TNS, section 4 and 6 of the POCSO Act. Not POCSO Act was inserted in the FIR because not according to the FIR, she says that she was 17 years old. And according to the FIR, the case of the victim is that the victim and the petitioner they were in talking terms. There were love affairs between the parties, and they exchanged their mobile phone. They were talking over the mobile phone.
183 statement कहाँ है victim का? Office is directed to call for the statement of the victim recorded under section 183 BNS along with her medical examination.
Medical examination they have come up with. In assembly of the contract.
And date of birth is also from this.
Not according to date of birth, we will see on the date of occurrence, 18 years, more than 18 years.
तो बैक में आने दीजिए. इसका 183 स्टेट. खाली 183 स्टेट. Communicate this order to us. Post on 5th of May.